In this video, we will explore 4 agreements that are void under the Indian law. First, agreements to stifle prosecution. Second, maintenance and champerty. Third, trading with an enemy. Fourth, marriage brokerage contracts.
Contracts are the backbone of businesses and personal agreements. However, every agreement is not legally enforceable. Some agreements are considered void because they go against public policies and which means they harm the society or legal system. Imagine you are a victim of a serious fraud. You reported the case and the case is about to go for a trial. Suddenly, the accused offers you some amount of money to stay silent and drop the charges. Would you take it? Some people might take it, some people might not take it. But what if I told you accepting such an offer is not just unethical but also illegal? Yes, this is what we call as agreement to stifle prosecution. And today we will explore why such agreements are completely against public policies. As I already said, an agreement to stifle prosecution is a contract where one party agrees to suppress or withdraw criminal proceedings in exchange of money or other benefits. Such agreements are considered void and illegal under Section 23 of Indian Contract Act 1872. This is based on a principle that crimes are offenses against society and not just an individual. Allowing private settlement would undermine law enforcement and public interest. Now, do we need to go to court for every single thing? This is where our next discussion comes. Compoundable and non-compoundable offenses. Compoundable offenses are less serious where the victim and the accused can mutually settle their dispute outside the court, but with the court's permission. This leads to the withdrawal of criminal cases. Some of the examples of compoundable offenses are simple hurt, criminal breach of trust, and defamation. This is because the law allows for such compromises and recognizes that it can lead to amicable resolution and reduce the burden on the courts. Whereas non-compoundable offenses, these are serious crimes against the society at large where compromises between parties is not legally permitted. No court of law can allow private parties to take administration of law in their hands and settle the question as to whether a particular offense has been committed or not by itself. Now, how do we know that an offense is compoundable or not? Section 320 of CRPC and now Section 359 of BNSS provides table listing of offences that are compoundable under IPC and now BNS. Offences not listed in these sections are considered non-compoundable.
My name is Raghavi Kalangudkar, roll number 43. I am going to talk on opposed to the public policy, where I am going to speak on the agreements of the maintenance and the champerty, where maintenance speaks that it is generally considered against the public policy. Maintenance refers to a third party unconnected to the litigation, assisting or encouraging a lawsuit, often by providing financial or the other support. For example, a person who is not involved in a property dispute but also agrees to fund the litigation for one of the parties is engaging in maintenance. Now I am going to speak on champerty. Champerty is generally considered against public policy. Champerty is where a third party funds a lawsuit with the understanding that they will receive a share of proceeds if the case is successful. For example, a person agrees to pay the legal fees for a plaintiff in a lawsuit with the understanding that if the plaintiff wins, they will receive a percentage of the damages awarded. Champerty and maintenance. All agreements of champerty or maintenance are not illegal in India, where such agreements appear to be made for gambling in litigation and injuring or oppressing others by encouraging unholy litigation, then they will not be enforced. Champerty and maintenance are not illegal in India, and courts will refuse to enforce such agreements only when they are found to be extortionate and unconscionable and not made with the bona fide object of assisting claims of person unable to carry on litigation himself.
Hello everyone, my topic is trading agreement with an enemy. So, trading agreement with an enemy is fundamentally about the legal restriction placed on the governments during the times of conflict. Many countries have specific legislation, often called Trading with the Enemy Acts, that outlines this prohibition. When there is war between two countries, it is unlawful and against the public policy that a person should trade with the subject of enemy country. If some rights in respect of contract have already accrued, the outbreak of the war does not put an end to those rights, but their enforcement is suspended until hostilities are over. For example, A country enter into a trade agreement with the B country, but due to war between them, it is against the public policy to do trade with the other country during the war.
Marriage brokerage contract involves a person agreeing to arrange a marriage between two individuals in exchange for consideration, such as payment. Such contracts are opposed and considered void as they go against public policy, which emphasizes the importance of free and deliberate decision making in choosing a marriage partner. Marriage brokerage contracts often involve intermediaries who may prioritize financial gain over the well-being of the individuals involved. Even if the contract offers a choice of potential partners, it is still considered void if it involves payment or other consideration. If an advance payment is made to procure a marriage partner but the intermediary fails to deliver the payment, can be recovered. For example, in the case of Herman versus Charlesworth promised to introduce a young man to Miss Herman in exchange for a payment of £52 in advance and £250 on the day of marriage. Despite his efforts, the marriage did not take place. Then Miss Herman successfully recovered the advance payment.
As we have seen, these agreements are void because they go against fairness and justice. Public policy ensures that contracts benefit society, not harm it.
So always check if an agreement aligns with public policy before signing it.